Question 1. Market research demonstrates that a small technology firm based in Alabama has developed a novel software algorithm with significant potential for the global market. The firm has filed an international patent application under the Patent Cooperation Treaty, PCT, and has designated numerous countries. The firm now faces the critical decision of which countries to enter the national phase in, given its limited budget. What is the most professionally responsible and strategically sound approach for the firm to determine its national phase entry strategy in countries outside of the United States? Option A. Conduct in-depth market research to identify countries with the highest commercial potential and the greatest risk of infringement, and then prioritize national phase entry in those specific jurisdictions. Option B. Defer the decision on national phase entry for as long as possible, waiting for further market developments and competitor actions to emerge before committing resources. Option C. Focus national phase entry on countries where the patent application process is perceived to be the least complex and costly, irrespective of market size or competitive activity. Option D. Pursue national phase entry in all countries designated in the PCT application to ensure the broadest possible protection, regardless of immediate commercial viability. The correct answer is A. Conduct in-depth market research to identify countries with the highest commercial potential and the greatest risk of infringement, and then prioritize national phase entry in those specific jurisdictions. Explanation. This scenario presents a common challenge for Alabama-based businesses seeking to protect their intellectual property internationally. The core difficulty lies in navigating the complexities of international patent filing strategies, specifically the transition from the Patent Cooperation Treaty, PCT, to national phase entry, while managing costs and strategic market entry. A careful balance must be struck between broad protection and focused investment. The best approach involves a strategic assessment of market viability and potential infringement risks in key target countries before committing to national phase entry. This means conducting thorough market research to identify jurisdictions where the invention has the highest commercial potential and where competitors are most likely to operate. Following this, a targeted filing strategy, prioritizing countries with strong patent protection and significant market share, is the most prudent course of action. This approach aligns with the principles of efficient resource allocation and maximizes the likelihood of obtaining meaningful protection in commercially relevant territories. It respects the economic realities of international patenting, which can be prohibitively expensive if pursued indiscriminately. Failing to conduct thorough market research and instead pursuing national phase entry in all PCT-designated countries is a significant regulatory and ethical misstep. This approach disregards the economic feasibility of obtaining and maintaining patents in numerous jurisdictions, potentially leading to wasted resources and a dilution of focus. It also fails to adequately consider the commercial value of the invention in each potential market, which is a fundamental aspect of responsible IP management. Another flawed approach is to prioritize countries based solely on the perceived ease of obtaining a patent, without considering market size or competitive landscape. This overlooks the primary purpose of patent protection, which is to secure commercial advantage. A patent in a market with little commercial activity or high enforcement barriers offers minimal practical benefit, representing a poor strategic decision. Finally, delaying the decision on national phase entry indefinitely, hoping for a clearer market picture, is also professionally unsound. The PCT provides a limited window for national phase entry. Procrastination beyond this deadline results in the loss of the priority date established under the PCT, severely diminishing the chances of obtaining patent protection in those desired jurisdictions. This inaction can lead to the invention becoming public knowledge or being patented by others, rendering the initial PCT application largely ineffective. Professionals should employ a systematic decision-making process that begins with a clear understanding of the business objectives and the commercial potential of the invention. This should be followed by a comprehensive analysis of target markets, including their economic significance, competitive intensity, and the strength of their patent systems. Based on this intelligence, a prioritized list of countries for national phase entry can be developed, ensuring that resources are allocated effectively to achieve the greatest strategic advantage. Question 2. Implementation of a patent enforcement strategy by an Alabama-based biotechnology startup holding a patent for a novel drug delivery system requires careful consideration of legal and ethical obligations. The startup's limited resources amplify the need for a judicious approach. Which of the following strategies best balances aggressive enforcement with responsible legal practice under Alabama and federal patent law? Option A. File a lawsuit immediately upon learning that a larger competitor is marketing a similar product, based on the assumption that their market presence implies infringement. Option B. Conduct a detailed infringement analysis by experienced patent counsel, comparing the patent claims to the accused product, and if the analysis reveals a high probability of infringement and a strong likelihood of success, proceed with a cease and desist letter, and if necessary, litigation. Option C. Initiate litigation based on rumors and anecdotal evidence from industry contacts, without conducting a thorough technical and legal investigation. Option D. Rely on a preliminary, informal opinion from a junior associate regarding potential infringement to initiate legal proceedings, without further independent verification. The correct answer is B. Conduct a detailed infringement analysis by experienced patent counsel, comparing the patent claims to the accused product, and if the analysis reveals a high probability of infringement and a strong likelihood of success, proceed with a cease and desist letter, and if necessary, litigation. Explanation. Scenario analysis. This scenario presents a common challenge in patent litigation, balancing the need for aggressive enforcement with the ethical and legal obligations to avoid frivolous claims and misrepresentations. The patent holder, a small Alabama-based biotechnology startup, is eager to protect its innovative drug delivery system. However, they are operating with limited resources, which can lead to pressure to pursue every perceived infringement, even if the evidence is weak. The opposing party, a larger pharmaceutical company, has significant legal resources, making a protracted and expensive legal battle a real threat. The challenge lies in strategically pursuing enforcement while adhering to Alabama and federal patent law, including the duty of candor, the United States Patent and Trademark Office (USPTO), and the courts. Missteps can lead to sanctions, loss of patent rights, and reputational damage. Correct approach analysis. The best professional approach involves a thorough, objective assessment of the infringement claim, supported by strong technical and legal analysis, for initiating litigation. This means engaging experienced patent counsel to conduct a detailed infringement analysis, comparing the claims of the Alabama startup's patent with the accused product. This analysis should consider claim construction, potential defenses, and the strength of the evidence. If the analysis reveals a high probability of infringement and a strong likelihood of success, then filing a cease and desist letter followed by a lawsuit, if necessary, is the appropriate course of action. This approach aligns with the principles of Rule 11 of the Federal Rules of Civil Procedure, which requires that pleadings be based on a reasonable inquiry into the facts and law, and that they are not interposed for any improper purpose. It also respects the court's time and resources by avoiding unnecessary litigation. Incorrect approaches analysis. Pursuing litigation based solely on a competitor's market presence and a general belief of infringement, without a detailed technical analysis of the patent claims against the accused product, is professionally unacceptable. This approach risks filing a lawsuit without a good faith basis, potentially violating Rule 11 and leading to sanctions. It also fails to adequately protect the patent holder's rights, as a weak or unsubstantiated claim is unlikely to succeed. Initiating litigation based on a preliminary, informal opinion from a junior associate without independent verification or a thorough review by senior patent counsel is also professionally unsound. While junior associates are valuable, critical legal assessments, especially those that form the basis of a lawsuit, require the expertise and oversight of experienced practitioners to ensure accuracy and compliance with legal standards. This approach risks overlooking crucial claim construction nuances or potential invalidity defenses. Relying on anecdotal evidence or rumors of infringement from industry contacts without conducting a rigorous technical and legal investigation is a significant ethical and professional failure. Such an approach lacks the necessary factual and legal foundation required for initiating patent litigation and could be construed as harassment or an abuse of the legal process. It also fails to provide the patent holder with a realistic assessment of their chances of success. Professional reasoning. Professionals facing such a situation should adopt a systematic decision-making process. First, they must engage qualified patent counsel to conduct a comprehensive infringement analysis. This analysis should include claim construction, comparison of the patent claims to the accused product, and an assessment of potential defenses. Second, Based on this objective analysis, counsel should advise the client on the strength of their case and the associated risks and costs. Third, if the analysis supports a strong claim, the next step would typically be a cease and desist letter, allowing the alleged infringer an opportunity to cease their activities. If that fails and the infringement analysis remains robust, then filing a lawsuit is the appropriate, albeit last, resort. Throughout this process, maintaining candor with the court and opposing counsel is paramount. Question 3. To address the challenge of a burgeoning Alabama-based tech startup seeking to maximize its immediate financial resources while simultaneously fostering long-term innovation and economic growth within the state, which strategic approach to its intellectual property, IP, portfolio is most professionally sound? Option A. Prioritize immediate cash flow by selling off all existing IP rights to investors, without retaining any future rights or considering potential licensing opportunities. Option B. Develop a comprehensive IP strategy that proactively identifies, protects, and commercializes innovations, aligning with market opportunities and potential licensing or sales strategies to maximize long-term economic benefits for the company in Alabama. Option C. Neglect formal IP protection measures, relying on the inherent novelty of the technology to deter competitors and assuming market dominance will naturally follow. Option D. Focus exclusively on obtaining patent protection for all innovations, disregarding other forms of IP such as trade secrets or trademarks that might also hold significant economic value. The correct answer is B. Develop a comprehensive IP strategy that proactively identifies, protects, and commercializes innovations, aligning with market opportunities and potential licensing or sales strategies to maximize long-term economic benefits for the company in Alabama. Explanation: this scenario is professionally challenging because it requires balancing the immediate financial needs of a startup with the long-term strategic value of intellectual property, IP, for innovation and economic growth in Alabama. A hasty decision could undervalue critical assets, hindering future development and competitiveness. Careful judgment is required to ensure that the IP strategy aligns with the company's overall business objectives and contributes positively to the state's economic landscape. The best approach involves a comprehensive IP strategy that leverages Alabama's specific legal and economic environment. The strategy should proactively identify, protect, and commercialize the startup's innovations, recognizing that strong IP rights can attract investment, foster collaboration, and create high-value jobs within Alabama. By aligning IP protection with market opportunities and potential licensing or sales strategies, the company can maximize the economic benefits derived from its intellectual assets, thereby contributing to Alabama's innovation ecosystem. This aligns with the principles of fostering economic growth through innovation, as supported by Alabama's legal framework for IP. An approach that prioritizes immediate cash flow by selling off all IP rights without considering future licensing or development potential is professionally unacceptable. This fails to recognize the long-term economic growth potential that IP can unlock for both the company and the state of Alabama. It represents a short-sighted view that neglects the strategic importance of IP as a driver of innovation and sustained economic development. Another unacceptable approach is to neglect IP protection altogether, assuming that the innovation will be self-sustaining or that competitors will not emerge. This ignores the fundamental role of IP law in providing exclusive rights, which are essential for recouping research and development costs and incentivizing further innovation. Without protection, the startup risks losing its competitive advantage and its ability to contribute to Alabama's economic growth through unique products or services. Finally, an approach that focuses solely on patent protection without considering other forms of IP, such as trade secrets or trademarks, is incomplete. While patents are crucial, a holistic IP strategy that encompasses all relevant forms of protection is necessary to safeguard the full spectrum of a company's innovations and their economic potential within Alabama. This limited scope can leave valuable aspects of the company's intellectual assets vulnerable. Professionals should employ a decision-making framework that begins with a thorough understanding of the startup's business goals and the specific IP landscape in Alabama. This involves assessing the nature of the innovations, identifying potential markets, and evaluating the most effective IP protection mechanisms available under Alabama law. The framework should then consider various commercialization strategies, including licensing, joint ventures, and potential acquisition, always prioritizing the long-term economic growth and innovation potential for the state. Question 4. The review process indicates that a patent attorney in Alabama is evaluating a newly synthesized chemical compound for patentability. The client claims the compound is entirely new and has unique therapeutic properties that could revolutionize a specific medical treatment. The attorney has conducted an initial search and found no direct disclosure of this exact compound. However, the attorney also noted that several closely related compounds with similar structural features have been patented or published, and some of these related compounds exhibit similar, albeit less potent, therapeutic effects. The attorney must now advise the client on the patentability of this compound under Alabama law. Which of the following approaches best represents the professional and legally sound course of action for the patent attorney? Option A. Recommend filing a patent application immediately, focusing solely on the novelty of the compound, and address any potential challenges regarding obviousness or utility only if they arise during the examination process. Option B. Advise the client that the compound is likely patentable due to its novelty, as no identical compound has been found in the prior art, and proceed with filing a patent application emphasizing its unique therapeutic properties. Option C. Advise the client that the compound is not patentable because the therapeutic properties, even if unique, are merely an extension of known effects from similar compounds, and the client should explore alternative avenues for protection. Option D. Inform the client that while the compound is novel, the existence of closely related compounds with similar therapeutic effects may render the invention obvious to a person of ordinary skill in the art, and therefore, patentability is questionable without further evidence of a significantly superior or unexpected utility. The correct answer is B. Advise the client that the compound is likely patentable due to its novelty, as no identical compound has been found in the prior art, and proceed with filing a patent application emphasizing its unique therapeutic properties. Explanation. The review process indicates a scenario where a patent attorney in Alabama must assess the patentability of a novel chemical compound. This situation is professionally challenging because it requires a nuanced application of Alabama patent law, specifically the criteria of novelty, non-obviousness, and utility, to a complex scientific invention. Misinterpreting these criteria can lead to the filing of an unpatentable patent application, wasting client resources and potentially damaging the attorney's reputation. Careful judgment is required to balance the client's desire for broad patent protection with the strict legal requirements. The best approach involves a thorough examination of the chemical compound against the prior art, focusing on whether the compound itself, or a very close analog, has been previously disclosed or made available to the public. This assessment must also consider whether the compound's properties or uses would have been obvious to a person of ordinary skill in the relevant chemical field at the time of invention, given the existing knowledge. Furthermore, the compound must demonstrate a specific, substantial, and credible utility. This means the invention must have a practical use that is more than a mere theoretical possibility. This comprehensive analysis ensures compliance with the core patentability requirements as defined under Alabama law, which mirrors federal patent law principles. An incorrect approach would be to solely focus on the novelty of the compound without adequately assessing non-obviousness. While the compound may be chemically distinct from anything previously known, if its properties or potential uses are predictable based on existing knowledge, it may still be deemed obvious and thus unpatentable. Another incorrect approach is to assume utility based on the compound's existence alone. Alabama patent law, like federal law, requires a demonstrated concrete utility, not just a theoretical one. Failing to establish this specific utility can render an otherwise novel and non-obvious invention unpatentable. A further flawed approach would be to prioritize the client's subjective belief in the invention's patentability over an objective legal assessment of the patentability criteria. Professional ethics and legal obligations mandate an objective evaluation based on established law, not client sentiment. Professionals should employ a systematic decision-making process that begins with a deep dive into the client's invention and its technical details. This should be followed by a comprehensive prior art search and analysis, meticulously comparing the invention against existing knowledge to assess novelty and non-obviousness. Concurrently, The invention's utility must be rigorously evaluated against the legal standard of specific, substantial, and credible use. This objective, legally grounded assessment forms the basis for advising the client on the likelihood of obtaining a patent and the scope of potential claims. Question 5. Examination of the data shows that an inventor in Alabama has developed a novel device and is preparing to file a patent application with the United States Patent and Trademark Office. The inventor is aware of several existing patents and publications that bear some resemblance to their invention, but they believe these do not fully anticipate or render their invention obvious. What is the most prudent course of action for the inventor regarding the disclosure of this known prior art during the patent application process? Option A. Proactively and comprehensively disclose all known prior art that is material to the patentability of the invention to the United States Patent and Trademark Office. Option B. Disclose only the prior art that the inventor believes clearly and unequivocally prevents patent issuance. Option C. Rely solely on the United States Patent and Trademark Office's own prior art search capabilities to identify relevant existing technologies. Option D. Intentionally omit or mischaracterize known prior art that the inventor believes is not critical to the patentability of their invention. The correct answer is A. Proactively and comprehensively disclose all known prior art that is material to the patentability of the invention to the United States Patent and Trademark Office. Explanation. Scenario analysis. This scenario presents a professional challenge for an inventor seeking patent protection in Alabama. The core difficulty lies in navigating the complex and time-sensitive requirements of the patent application process, specifically concerning the disclosure of prior art. Failure to properly disclose known prior art can lead to patent invalidity, rendering the inventor's efforts and potential investment moot. Careful judgment is required to ensure compliance with Alabama and federal patent law, which prioritizes transparency and good faith in the application process. Correct approach analysis. The best professional approach involves proactively and comprehensively disclosing all known prior art that is material to the patentability of the invention. This means identifying any existing patents, publications, or public uses that could be relevant to the novelty or obviousness of the claimed invention. This approach is correct because it aligns directly with the duty of candor and good faith owed to the United States Patent and Trademark Office USPTO under 37 CFR Section 156. This regulation mandates that all individuals associated with the filing and prosecution of a patent application have a duty to disclose to the office all information known to them to be material to patentability. By disclosing known prior art, the inventor demonstrates good faith, facilitates a more efficient examination, and significantly strengthens the enforceability of any granted patent. This proactive disclosure minimizes the risk of future challenges based on undisclosed prior art. Incorrect approaches analysis. One incorrect approach is to only disclose prior art that the inventor believes is clearly relevant and would prevent patent issuance. This approach fails because the materiality standard under 37 CFR Section 156 is broad. Information is material if it establishes, by itself or in combination with other information, a prima facie case of unpatentability of a claimed invention. The inventor's subjective belief about relevance is insufficient. The USPTO examiner ultimately determines materiality. Holding potentially relevant information, even if the inventor believes it's not a showstopper, violates the duty of disclosure and can lead to inequitable conduct, a serious charge that can render a patent unenforceable. Another incorrect approach is to assume that the USPTO will find all relevant prior art through its own search. While the USPTO conducts its own prior art searches, this does not absolve the applicant of their duty to disclose what they know. Relying solely on the USPTO search is a dereliction of the applicant's statutory and regulatory obligations. This failure can result in a patent being granted on an invention that is not truly novel or non-obvious, and if the undisclosed prior art is later discovered, it can be grounds for invalidating the patent. A further incorrect approach is to intentionally omit or mischaracterize known prior art in the application. This is not only a violation of the duty of candor, but constitutes active deception. Such conduct can lead to a finding of inequitable conduct, which is a severe ethical and legal breach. The consequences of inequitable conduct can include the unenforceability of the patent and potential sanctions against the applicant and their legal representatives. Professional reasoning. Professionals faced with this situation should adopt a better safe than sorry mentality regarding prior art disclosure. The decision-making process should involve a thorough internal review of all known prior art, followed by consultation with patent counsel to assess materiality. The guiding principle should be to err on the side of disclosure. If there is any doubt about the materiality of a piece of prior art, it should be disclosed. This approach not only ensures compliance with USPTO regulations, but also builds a stronger foundation for the patent's validity and enforceability, ultimately protecting the inventor's intellectual property rights. Question 6. Upon reviewing a client's detailed technical notes and preliminary sketches for a novel chemical process developed in Alabama, an intellectual property attorney is tasked with preparing a patent application. The inventor expresses a strong desire to claim any and all methods of producing this compound. Even though their notes primarily detail a specific reaction pathway and a limited set of starting materials, the attorney has conducted an initial prior art search which reveals several related but not identical chemical processes. What is the most ethically sound and legally effective approach for the attorney to take in preparing the patent application? Option A. Draft claims that are extremely narrow, focusing only on the most minute, undisputed novel aspect described, to guarantee allowance and avoid any potential objections. Option B. Draft claims that precisely define the specific reaction pathway and starting materials detailed in the inventor's notes, while also exploring claims for broader, yet still patentably distinct, variations of the process based on the attorney's understanding of chemical principles and the prior art. Option C. Draft claims that broadly encompass any and all methods of producing this compound, as requested by the inventor, assuming the USPTO will narrow them during examination. Option D. Incorporate general descriptions of chemical synthesis techniques found in common textbooks into the claims to broaden their scope, even if these techniques were not specifically used or conceived by the inventor. The correct answer is B. Draft claims that precisely define the specific reaction pathway and starting materials detailed in the inventor's notes, while also exploring claims for broader, yet still patentably distinct, variations of the process based on the attorney's understanding of chemical principles and the prior art. Explanation. This scenario presents a professional challenge for an Alabama patent attorney due to the critical need to accurately and comprehensively capture the inventor's contributions, while adhering to the strict requirements of the United States Patent and Trademark Office (USPTO), as applied in Alabama. The attorney must balance the inventor's desire for broad protection with the legal and ethical obligations to present only patentable subject matter and to avoid misleading the Patent Office. Careful judgment is required to ensure the application is both effective for the client and compliant with federal patent law. The best approach involves meticulously reviewing the inventor's detailed notes and prior art, identifying the core inventive concepts, and then drafting claims that precisely define these novel and non-obvious aspects. This method ensures that the patent application accurately reflects the invention's true scope, aligns with the statutory requirements for patentability under 35 U.S.C. Section 101, Section 102, and Section 103, and avoids overreach. By focusing on what is truly new and inventive, the attorney fulfills their duty of candor and good faith to the USPTO, as mandated by 37 C.F.R. Section 156, and ethically represents the client's interests by seeking protection for a valid invention. An approach that focuses solely on the inventor's broad, aspirational descriptions without a rigorous analysis of novelty and non-obviousness against the prior art risks, submitting claims that are unpatentable. His failure to adequately assess patentability under 35 U.S.C. Section 102 and Section 103 can lead to rejections and wasted client resources, and potentially violates the duty of candor if the attorney knows or should know the claims lack merit. Another unacceptable approach is to draft claims that are so narrow they fail to capture the essence of the inventor's intended protection, even if technically novel. While avoiding overreach is important, the attorney has a duty to secure the broadest possible protection for a valid invention. Failing to adequately explore the scope of patentable subject matter, even if it requires more extensive research and drafting, is a disservice to the client and may not fully meet the attorney's professional obligations. Finally, incorporating elements that are clearly in the public domain or are merely functional descriptions without a specific structural or procedural novelty would be a significant ethical and legal misstep. This would not only be unpatentable under 35 U.S.C. Section 101, but would also violate the duty of candor to the USPTO. The professional decision-making process should involve a thorough understanding of the invention, a comprehensive search of relevant prior art, a critical assessment of patentability criteria, novelty, non-obviousness, utility, and subject matter eligibility, and the drafting of claims that accurately and effectively define the invention within the bounds of federal patent law and USPTO regulations. Question 7. When evaluating the international intellectual property protection for a software developer based in Alabama, whose new application code was created entirely within the state, and who wishes to protect this code from unauthorized use in France, which is also a signatory to the Berne Convention, what is the most prudent course of action for the developer's legal counsel in Alabama? Option A. Inform the client that no action is necessary, as the Berne Convention guarantees full and equivalent protection in France without any need for further steps, and that French courts will automatically recognize and enforce the copyright. Option B. Recommend that the client immediately file for copyright registration in France, as this is the only way to secure any form of copyright protection for their application code in that country, irrespective of the Berne Convention. Option C. Advise the client to focus solely on obtaining a patent for the software in Alabama, as this is the most robust form of protection available for software and will automatically extend to France under international patent treaties. Option D. Advise the client that under the Berne Convention, copyright protection for the application code is automatic in France due to both countries being signatories, but also recommend exploring registration options in Alabama to facilitate potential enforcement actions and to establish a clear record of ownership, while noting that French law will govern enforcement there. The correct answer is D. Advise the client that under the Berne Convention, copyright protection for the application code is automatic in France due to both countries being signatories, but also recommend exploring registration options in Alabama to facilitate potential enforcement actions and to establish a clear record of ownership, while noting that French law will govern enforcement there. Explanation. This scenario presents a professional challenge because it requires balancing the protection of a client's intellectual property rights with the obligations and benefits derived from international IP treaties. A thorough understanding of Alabama's adherence to these treaties, particularly the Berne Convention and the Paris Convention, is crucial for advising clients effectively on cross-border IP protection. The challenge lies in navigating the nuances of national treatment, automatic protection, and the specific procedural requirements that may still apply, even under treaty provisions. The best approach involves recognizing that, while international treaties like the Berne Convention provide automatic copyright protection for works originating in member states, Alabama law, as it implements these treaties, still necessitates understanding the client's specific situation. This includes confirming the origin of the work and ensuring that the client can demonstrate ownership and compliance with any foundational requirements for protection under Alabama law, even if formal registration is not strictly mandatory for basic rights. This approach aligns with the principle of national treatment, ensuring the client receives the same protection in Alabama as a domestic work, while also acknowledging that practical steps may be needed to enforce those rights effectively. An incorrect approach would be to assume that treaty provisions completely negate the need for any consideration of Alabama's domestic IP framework. For instance, advising the client that no action is required whatsoever, without verifying the work's origin or potential for future enforcement challenges, overlooks the practical realities of IP law. While the Berne Convention grants automatic copyright, the ability to sue for infringement or to benefit from statutory damages and attorney's fees in Alabama often hinges on registration, even if not a prerequisite for the existence of the copyright itself. Similarly, advising the client to rely solely on the Paris Convention for trademark protection without considering Alabama's specific registration and use requirements for establishing and enforcing trademark rights within the state would be a failure. The Paris Convention primarily deals with priority claims and national treatment for patents, trademarks, and industrial designs, but it does not grant automatic rights within a member state without compliance with that state's laws. Professionals should approach such situations by first identifying the client's IP assets and their origin. They should then research how Alabama law implements relevant international treaties, such as the Berne Convention for copyright, and the Paris Convention for Industrial Property. This involves understanding the scope of protection granted by these treaties and any corresponding obligations or recommended practices under Alabama law. The professional should then advise the client on the most effective strategy for securing and enforcing their rights, which may include registration even when not strictly mandatory, to maximize legal recourse and protection within Alabama. Question 8. The analysis reveals that Innovate Solutions, Inc. in Alabama has developed a new software algorithm that significantly enhances the efficiency of data processing. A competitor, Data Crunchers Corp., has recently launched a similar product that appears to utilize the core principles of Innovate Solutions, Inc.'s patented algorithm. Data Crunchers Corp. claims their product was developed independently. However, evidence suggests that a former employee of Innovate Solutions, Inc., who had intimate knowledge of the patented algorithm, now works for Data Crunchers Corp. and was instrumental in the development of their competing product. Considering the potential for patent infringement under Alabama law, what is the most appropriate initial course of action for Innovate Solutions, Inc. to assess the situation? Option A. Focus on whether the former employee of Innovate Solutions, Inc. intentionally shared confidential information with Data Crunchers Corp. to encourage the development of a competing product. Option B. Investigate whether Data Crunchers Corp. directly copied or reproduced the patented algorithm without authorization, focusing on the functionality and output of their product in comparison to the patented invention. Option C. Assess whether Innovate Solutions, Inc. has a strong business relationship with Data Crunchers Corp. that could be leveraged to negotiate a licensing agreement. Option D. Determine if Data Crunchers Corp. is selling the patented algorithm as a standalone product or as part of a larger system without proper licensing. The correct answer is B. Investigate whether Data Crunchers Corp. directly copied or reproduced the patented algorithm without authorization, focusing on the functionality and output of their product in comparison to the patented invention. Explanation. The analysis reveals a scenario that is professionally challenging due to the nuanced distinctions between different types of intellectual property infringement under Alabama law. Determining liability requires a careful assessment of intent, knowledge, and the nature of the involvement in the infringing activity. Professionals must navigate the complexities of direct, indirect, and contributory infringement to accurately advise clients and pursue appropriate legal remedies. The best approach involves a thorough investigation into whether Innovate Solutions, Inc. directly copied or reproduced the patented technology without authorization. This direct infringement occurs when a party violates one or more of the exclusive rights granted to the patent holder, such as the right to make, use, sell, offer for sale, or import the patented invention within Alabama. Alabama law, mirroring federal patent law principles, holds that direct infringement is the most straightforward form of violation, occurring when the alleged infringer performs the prohibited acts. This approach is correct because it focuses on the core act of unauthorized use of the patented invention, which is the fundamental basis for patent protection. An incorrect approach would be to solely focus on whether Innovate Solutions, Inc. induced or encouraged Tech Gadgets LLC to infringe the patent, without establishing that Tech Gadgets LLC itself committed direct infringement. While inducing infringement is a form of indirect infringement, it requires proof that the alleged inducer possessed knowledge of the patent and specific intent to encourage infringement. Without evidence of direct infringement by Tech Gadgets LLC or that Innovate Solutions, Inc. actively encouraged such direct infringement with knowledge, this line of reasoning is incomplete. Another incorrect approach would be to claim Innovate Solutions, Inc. is liable for contributory infringement simply because it supplied components that could be used in an infringing manner, without demonstrating that these components have no substantial non-infringing use and that Innovate Solutions, Inc. knew of the patent and knew that the components would be used to infringe. Contributory infringement requires a higher threshold of knowledge and intent than merely supplying a component. Finally, an incorrect approach would be to assume that any business relationship between Innovate Solutions, Inc. and Tech Gadgets LLC automatically equates to infringement. Liability for infringement, whether direct or indirect, requires specific actions that violate the patent holder's exclusive rights, not merely a business association. Professionals should employ a decision-making framework that begins with identifying the specific patent rights allegedly infringed. This is followed by a factual investigation to determine if any party has directly violated those rights. if direct infringement is established. The analysis then extends to whether any other parties induced or contributed to that infringement, considering the requisite levels of knowledge and intent for each type of indirect infringement under Alabama law. Question 9. Comparative studies suggest that patent licensing strategies can significantly impact a company's long-term profitability. An Alabama-based technology firm, Innovate Solutions, holds a patent for a novel manufacturing process. They have identified a potential licensee in Europe who expresses strong interest in utilizing this process. Innovate Solutions is seeking to maximize its return on investment while mitigating risks. Considering the principles of patent licensing under Alabama law, which of the following approaches would best serve Innovate Solutions' interests? Option A. Negotiate an exclusive license for the European market, with royalties structured as a percentage of the licensee's net sales within that territory, and include provisions for periodic review of royalty rates based on market performance. Option B. Grant a worldwide non-exclusive license to the European company, with a nominal upfront fee and a very low, fixed annual royalty payment regardless of sales volume. Option C. Immediately initiate infringement lawsuits against all companies in Europe that might be using a similar process, without first exploring licensing options. Option D. Assign the entire patent rights for the manufacturing process to the European company in exchange for a one-time lump sum payment. The correct answer is A. Negotiate an exclusive license for the European market, with royalties structured as a percentage of the licensee's net sales within that territory, and include provisions for periodic review of royalty rates based on market performance. Explanation. This scenario presents a professional challenge due to the inherent complexities of patent licensing and assignment under Alabama law, particularly when dealing with potential infringement and the need to secure future revenue streams. The core difficulty lies in balancing the immediate need for financial compensation with the long-term strategic value of the patent portfolio and the potential risks associated with a broad, unrestricted license. Careful judgment is required to ensure the chosen licensing strategy maximizes benefit while minimizing legal and financial exposure. Adhering strictly to Alabama's intellectual property framework, the correct approach involves a carefully structured exclusive license with clear territorial limitations and a robust royalty structure tied to the licensee's actual sales within those territories. This strategy is correct because it aligns with the principles of patent law in Alabama, which permit the owner to grant exclusive rights within defined geographical areas. The royalty structure, tied to sales, ensures that the licensor benefits directly from the licensee's commercial success, reflecting the value of the patented technology. Furthermore, by limiting the exclusivity geographically, the licensor retains the flexibility to license other territories or pursue other commercialization strategies independently, thereby maximizing the overall potential return on the patent investment. This approach respects the rights of the patent holder while providing a clear framework for the licensee's operations, minimizing ambiguity and potential disputes. An incorrect approach would be to grant a broad, worldwide non-exclusive license without any minimum royalty guarantees or performance milestones. This is professionally unacceptable because it fails to adequately protect the licensor's interests. A non-exclusive license, especially a worldwide one, significantly dilutes the value of the patent, as multiple parties could potentially exploit it without significant commitment. The absence of minimum royalties or performance metrics means the licensor might receive minimal or no income, even if the technology has substantial market potential. This approach neglects the fundamental principle of maximizing the economic benefit derived from the patent rights granted under Alabama law. Another incorrect approach would be to assign the patent outright without retaining any future rights or royalties. This is professionally unacceptable as it relinquishes all future control and potential revenue from the patent. Assignment, under Alabama law, transfers ownership entirely. While it provides immediate capital, it forfeits any ongoing benefit from the patent's commercial success, which could far outweigh the initial sale price over time. This strategy fails to leverage the long-term value of the intellectual property. Finally, an incorrect approach would be to pursue immediate litigation against all potential infringers without first attempting to negotiate a licensing agreement. While litigation is a tool to enforce patent rights, it is often costly, time-consuming, and uncertain. Without a clear licensing strategy in place, this approach can drain resources and may not result in sustainable revenue. It prioritizes enforcement over strategic commercialization, which is often a less effective way to realize the full economic potential of a patent under Alabama law. Professionals should employ a decision-making framework that begins with a thorough understanding of the patent's commercial potential and the target market. This involves assessing the competitive landscape, identifying potential licensees, and evaluating the risks and rewards of different licensing structures. The framework should prioritize strategies that provide a balance between immediate financial return and long-term value maximization, always ensuring compliance with Alabama's intellectual property statutes and case law. Negotiation and clear contractual terms are paramount to avoid future disputes and ensure the successful exploitation of the patent. Question 10. The investigation demonstrates that a software development company in Alabama is creating a new mobile video game that incorporates a short, recognizable melody from a popular song released in 1985. The game uses the melody as background music during a specific in-game event that lasts approximately 15 seconds. The company's legal counsel has calculated that if the use is deemed infringing, potential statutory damages under Alabama law could range from $750 to $30,000 per infringed work, assuming the court finds willful infringement. The company has not sought a license from the copyright holder of the song. The developers argue that their use is transformative because the melody is used in a new context within the game, creating a different artistic expression and not directly competing with the original song's market. What is the most legally sound and professionally responsible course of action for the Alabama-based company? Option A. Conduct a detailed, multi-factor fair use analysis under Alabama law, focusing on the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect on the potential market for or value of the copyrighted work, to determine if the use is permissible. Option B. Calculate the maximum potential statutory damages, $30,000, and set aside that amount as a contingency, then proceed with the game's release, considering the risk of litigation as a business expense. Option C. Immediately cease all development of the game and seek to negotiate a licensing agreement with the copyright holder, regardless of the nature of the use, to avoid any potential legal disputes. Option D. Proceed with the game's development and release, assuming that the short duration of the melody and its use in a new context automatically qualify as fair use without further legal scrutiny. The correct answer is A. Conduct a detailed, multi-factor fair use analysis under Alabama law, focusing on the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect on the potential market for or value of the copyrighted work, to determine if the use is permissible. Explanation. 1. Scenario analysis. This scenario is professionally challenging because it requires a nuanced understanding of Alabama's fair use doctrine, specifically how it applies to transformative commercial use of copyrighted material. The core tension lies in balancing the rights of the copyright holder with the public interest in promoting creativity and innovation through the limited use of existing works. Determining whether a use is fair involves a multi-factor analysis, and misinterpreting these factors can lead to costly infringement claims. Calculation of potential damages further complicates the decision-making process, demanding a precise application of legal principles to financial figures. 2. Correct approach analysis. The best professional approach involves a thorough, multi-factor fair use analysis under Alabama law, focusing on the 4 statutory factors. 1. The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4. The effect of the use upon the potential market for or value of the copyrighted work. In this case, the developer's use is commercial, but the transformative nature of the game, creating a new expression and meaning from the original song lyrics, weighs heavily in favor of fair use. The limited use of the song's melody and the lack of direct market harm to the original song's sales or licensing opportunities further strengthen the fair use argument. The calculation of potential statutory damages, if infringement were found, be backslash text statutory damages equals text number of infringed works times text minimum statutory damage to /text number of infringed works /times /text maximum statutory damage /. Given the transformative use and minimal market impact, the likelihood of statutory damages being awarded at the lower end, or not at all, is high, making a reasoned fair use defense the most prudent and legally sound strategy. 3. Incorrect approaches analysis. One incorrect approach would be to ignore the fair use doctrine entirely and proceed with the commercial development and release of the game without any legal analysis or licensing. This is professionally unacceptable because it disregards established Alabama copyright law and exposes the developer to significant legal and financial risks, including potential injunctions, actual damages, and statutory damages. Another incorrect approach would be to solely focus on the commercial nature of the use and assume that any commercial use automatically constitutes infringement. This fails to recognize that commercial use is only one factor in the fair use analysis, and that transformative commercial uses can indeed be considered fair. This approach would lead to unnecessary licensing costs or abandonment of a potentially valuable project. A third incorrect approach would be to perform a superficial analysis of the fair use factors, perhaps only considering the amount of the song used, and concluding that fair use does not apply. This is professionally deficient, as it neglects the critical purpose and character of the use and effect on the market factors, which are often dispositive in cases of transformative use. Such a shallow analysis could lead to a wrongful determination of infringement or a missed opportunity to assert a valid defense. 4. Professional reasoning. Professionals facing similar situations should adopt a structured, analytical approach. First, identify the core legal issue in this case, potential copyright infringement, and the applicability of the fair use defense. Second, thoroughly research and apply the relevant jurisdiction's legal framework, Alabama intellectual property law. Third, conduct a comprehensive, multi-factor analysis of the defense, weighing all statutory considerations. Fourth, quantify potential financial risks and benefits, including estimated damages and licensing costs. Finally, make a reasoned decision based on the legal analysis and risk assessment, prioritizing compliance with the law and protecting the client's interests. Question 11. Analysis of a new product developed by an Alabama-based artisan, a smart garden gnome that incorporates a Bluetooth speaker and LED lights controlled by a mobile app, presents a jurisdictional question regarding intellectual property protection under Alabama law. The artisan has sculpted the gnome with a unique, whimsical aesthetic, including hand-painted details and a distinctive hat design. The smart features are integrated seamlessly into the gnome's form, with the speaker grill designed to resemble a mushroom cap and the LED eyes providing illumination. The artisan seeks to understand if this creation is eligible for copyright protection in Alabama. Which of the following best describes the copyright eligibility of the smart garden gnome under Alabama law? Option A. The smart garden gnome is eligible for copyright protection solely based on the innovative integration of smart technology, regardless of its artistic merit or visual design. Option B. The smart garden gnome is eligible for copyright protection because its unique artistic design, including the sculpted form, hand-painted details, and the aesthetic integration of technological components, constitutes an original work of authorship fixed in a tangible medium. Option C. The smart garden gnome is not eligible for copyright protection because the inclusion of functional technological elements, such as the Bluetooth speaker and LED lights, renders the entire creation utilitarian and therefore outside the scope of copyright. Option D. The smart garden gnome is not eligible for copyright protection because the underlying concept of a smart garden gnome is an idea, and copyright law only protects the expression of ideas, not the ideas themselves. The correct answer is B. The smart garden gnome is eligible for copyright protection because its unique artistic design, including the sculpted form, hand-painted details, and the aesthetic integration of technological components, constitutes an original work of authorship fixed in a tangible medium. Explanation. Analysis of this scenario is professionally challenging because it requires distinguishing between a creative expression that meets Alabama's originality and fixation requirements for copyright protection and a mere idea or functional design that does not. The core tension lies in determining if the smart features, while innovative, are expressed in a tangible form that qualifies for copyright. Careful judgment is required to avoid overextending copyright protection to unprotectable subject matter. The best professional approach involves recognizing that while the underlying concept of a smart garden gnome might be patentable or protectable through trade secrets, the specific artistic expression of that concept is what copyright law in Alabama protects. This approach correctly identifies that the visual design of the gnome, including its unique aesthetic features, and the way the smart technology is integrated into its physical form, e.g., the sculpted details of the speaker grill resembling a mushroom cap, the LED eyes, constitutes an original work of authorship fixed in a tangible medium. The integration of the technology is not merely functional. It is part of the artistic expression of the gnome's character and appearance. This aligns with Alabama law's emphasis on originality, independent creation, and a modicum of creativity and fixation, embodied in a copy or phonorecord from which it can be perceived or reproduced. An incorrect approach would be to dismiss the entire creation as unprotectable, because the smart features are functional. This fails to recognize that copyright can subsist in the artistic elements of a utilitarian article, provided those elements can be identified separately from, and are capable of existing independently of, the utilitarian aspects. Simply because the gnome has a function does not strip its sculpted form and aesthetic design of copyright protection. Another incorrect approach would be to assume that any novel technological integration automatically grants copyright protection to the entire product. Copyright protects the expression of an idea, not the idea itself or the functional aspects of a device. The innovation in the technology might be patentable, but the copyrightable element is how that innovation is artistically embodied. Professionals should employ a decision-making framework that first identifies the subject matter of the creation. Then they must assess whether the work demonstrates originality, meaning it was independently created and possesses at least a minimal degree of creativity. Finally, they must determine if the work is fixed in a tangible medium. For works with utilitarian aspects, the crucial step is to analyze whether there is an artistic or expressive component that can be conceptually separated from the functional elements, and if that expressive component meets the originality and fixation test. Question 12. Consider a scenario where a client in Alabama is eager to launch a new line of artisanal food products under the brand name Southern Spice Secrets. They have already invested in packaging and marketing materials and are pushing for an immediate launch. However, their legal counsel, licensed in Alabama, has a nagging concern that the name might be confusingly similar to existing food-related trademarks used within the state. What is the most prudent course of action for the Alabama licensed attorney? Option A. Conduct a quick online search of federal and Alabama trademark databases and proceed with the launch if no identical matches are found. Option B. Advise the client to proceed with the launch, but to be prepared to defend against any potential infringement claims that may arise. Option C. Advise the client to immediately halt all marketing and sales activities for Southern Spice Secrets until a comprehensive trademark search and clearance opinion can be obtained. Option D. Proceed with the launch as planned, as the client has already invested in marketing materials and has not yet received any objections. The correct answer is C. Advise the client to immediately halt all marketing and sales activities for Southern Spice Secrets until a comprehensive trademark search and clearance opinion can be obtained. Explanation. Scenario analysis. This scenario presents a common challenge in intellectual property law, balancing the client's desire for rapid market entry with the legal imperative to conduct thorough due diligence to avoid infringement. The professional challenge lies in advising the client on the risks associated with proceeding without adequate clearance, which could lead to costly litigation, injunctions, and reputational damage. Careful judgment is required to assess the likelihood of infringement and to communicate these risks effectively to the client, who may not fully appreciate the legal complexities. Correct approach analysis. The best professional practice involves advising the client to halt all marketing and sales activities related to the potentially infringing product until a comprehensive trademark search and clearance opinion can be obtained. This approach is correct because it prioritizes risk mitigation and adherence to Alabama trademark law, specifically the principles of likelihood of confusion under Alabama Code Section 8-12-1 et sec. Alabama Trademark Act. A thorough search and opinion are essential to determine if the proposed mark is confusingly similar to existing registered or unregistered marks used in commerce within Alabama. By advising a halt, the attorney is fulfilling their duty of zealous representation while also acting ethically to prevent the client from incurring further liability. This proactive measure safeguards the client's business interests and upholds the integrity of the trademark system. Incorrect approaches analysis. Proceeding with marketing and sales while a search is pending is professionally unacceptable. This approach disregards the potential for immediate infringement and the severe consequences that could follow, such as an injunction preventing further sales and significant damages. It prioritizes the client's immediate commercial goals over legal compliance and the attorney's duty to advise on risk. Relying solely on a quick online search without a formal clearance opinion is also professionally unsound. While an initial search can be a starting point, it is insufficient to identify all potentially conflicting marks, especially unregistered marks or marks used in specific niches within Alabama. Alabama law protects unregistered marks under common law principles, which a superficial search might miss. This approach fails to provide the client with a well-reasoned legal opinion on the registrability and potential for infringement of their mark. Assuming that because the client has not received any cease and desist letters yet, their mark is clear is a dangerous assumption. The absence of past enforcement does not guarantee future freedom from claims. Competitors may not be aware of the client's use, or they may be preparing to take action. This approach neglects the proactive nature of trademark clearance and exposes the client to unforeseen legal challenges. Professional reasoning. Professionals should adopt a risk-based decision-making framework. When faced with potential intellectual property infringement, the primary consideration must be the legal and financial exposure to the client. This involves 1. Identifying the potential risk, e.g., likelihood of confusion. 2. Assessing the severity of the risk, e.g., potential for injunction damages. 3. Determining the best course of action to mitigate the risk, e.g., conducting a thorough search and obtaining a legal opinion. 4. Communicating these risks and recommended actions clearly and comprehensively to the client, ensuring they understand the implications of their decisions. The attorney's role is to provide informed legal counsel, not to gamble on the client's behalf. Question 13. During the evaluation of a potential patent filing for a novel manufacturing process developed by an inventor in Mobile, Alabama, a junior associate proposes submitting a provisional patent application. The associate suggests including only a high-level overview of the process and a few key claims, believing this will be sufficient to establish an early filing date under Alabama law. What is the most appropriate course of action for the supervising attorney to ensure compliance with Alabama intellectual property law? Option A. Suggest that the associate consult general patent law resources to understand the typical components of a provisional application, as Alabama law is likely to align with these general principles. Option B. Authorize the associate to file the application with the proposed limited content, noting that the Patent Office will likely request further information if anything is missing. Option C. Instruct the associate to thoroughly review the Alabama Intellectual Property Act for the specific requirements of a provisional patent application specification and drawings, ensuring all necessary descriptive content is included before filing. Option D. Advise the associate to proceed with the filing as proposed, emphasizing that the primary goal of a provisional application is simply to secure an early filing date, and detailed content can be added later. The correct answer is C. Instruct the associate to thoroughly review the Alabama Intellectual Property Act for the specific requirements of a provisional patent application specification and drawings, ensuring all necessary descriptive content is included before filing. Explanation. Scenario analysis. This scenario presents a professional challenge due to the critical nature of intellectual property protection and the strict deadlines associated with patent applications. Misinterpreting or misapplying the filing requirements under Alabama law can lead to the irreversible loss of patent rights, creating significant financial and strategic disadvantages for the inventor. The professional must exercise meticulous attention to detail and a thorough understanding of the Alabama Intellectual Property Act's procedural mandates. Correct approach analysis. The best professional practice involves diligently reviewing the Alabama Intellectual Property Act for specific requirements regarding the submission of provisional patent applications, particularly concerning the content and format of the specification and drawings. This approach ensures compliance with all statutory mandates, thereby securing the earliest possible filing date and preserving the inventor's rights. Adhering strictly to the Act's provisions, such as those detailing the necessary components of a provisional application, e.g., A written description of the invention, drawings if necessary to understand the invention, is paramount. This proactive and compliant method directly addresses the legal requirements for establishing a priority date under Alabama law. Incorrect approach is analysis. Filing a provisional application with only a brief summary of the invention, without the detailed written description and drawings required by the Alabama Intellectual Property Act, is professionally unacceptable. This failure to meet the statutory content requirements means the application may not be considered complete, potentially jeopardizing the establishment of a valid filing date and the associated priority rights. Submitting a provisional application that omits any drawings, even when the Alabama Intellectual Property Act implicitly or explicitly suggests their utility for understanding the invention, is also professionally unsound. Not all provisional applications require drawings. Their exclusion when they would significantly aid in the description of the invention can lead to an incomplete application in the eyes of the Patent Office, undermining the purpose of securing a filing date. Relying on general knowledge of patent filing procedures without consulting the specific provisions of the Alabama Intellectual Property Act for provisional applications is a critical ethical and professional failure. Alabama law dictates the precise requirements for establishing a filing date, and generic assumptions can lead to noncompliance, resulting in the loss of valuable intellectual property rights. Professional reasoning. Professionals should adopt a systematic approach to application filing. This involves first identifying the relevant jurisdiction, Alabama, and the specific governing statutes, Alabama Intellectual Property Act. Next, they must thoroughly research the statutory requirements for the particular type of application being filed, provisional patent. This research should focus on the mandatory content, format, and submission procedures. Any ambiguity should be resolved by consulting official guidance or seeking clarification from the relevant authorities. Finally, a checklist based on the statutory requirements should be used to ensure all elements are present and correctly submitted before filing. Question 14. Research into a competitor's recent filing for a trademark registration with the Alabama Secretary of State reveals a mark that is strikingly similar to your client's established and widely recognized brand in the state. The competitor's mark, if registered, could lead to significant customer confusion and dilution of your client's brand equity. What is the most prudent and legally sound course of action to protect your client's intellectual property rights in Alabama? Option A. Immediately file a notice of opposition with the Alabama Secretary of State's office to formally challenge the competitor's trademark application. Option B. Advise the client to monitor the competitor's activities closely and wait to see if actual customer confusion arises before taking any action. Option C. Recommend that the client focus on their own business operations and marketing efforts, as legal challenges can be costly and time-consuming. Option D. Contact the competitor directly to express concerns about their trademark filing and request they withdraw their application. The correct answer is A. Immediately file a notice of opposition with the Alabama Secretary of State's office to formally challenge the competitor's trademark application. Explanation. 1. Scenario analysis. This scenario is professionally challenging because it involves a delicate balance between protecting a client's established intellectual property rights and the potential for a competitor to gain market share through a similar, yet potentially infringing, mark. The attorney must navigate the procedural complexities of opposition proceedings under Alabama law, ensuring timely and effective action to prevent dilution or confusion, while also considering the strategic implications of the timing and scope of the opposition. The risk of inaction could lead to significant future legal battles and financial losses for the client. 2. Correct approach analysis. The best professional approach involves immediately filing a notice of opposition with the Alabama Secretary of State's office. This action formally initiates the opposition proceeding, preventing the competitor's mark from being registered and providing a legal framework to challenge its validity. This approach is correct because it directly addresses the potential infringement by utilizing the statutory mechanism designed for such situations. Alabama law, specifically through the procedures outlined by the Secretary of State for trademark registration and opposition, mandates timely action to protect existing rights. Filing the opposition promptly ensures the client's rights are asserted within the legally prescribed timeframe, preventing the competitor's mark from gaining registration and potentially causing irreparable harm. 3. Incorrect approaches analysis. Failing to file a notice of opposition and instead waiting to see if the competitor's mark causes actual confusion is professionally unacceptable. This approach ignores the proactive measures available under Alabama law to prevent potential infringement before it occurs. It relies on a reactive strategy that is more difficult and costly to pursue, as proving actual confusion can be a high evidentiary bar. Furthermore, it risks allowing a confusingly similar mark to become registered, which can dilute the client's brand and create market confusion, undermining the purpose of trademark protection. Another unacceptable approach is to contact the competitor directly to express concerns, without initiating a formal opposition. While informal communication can sometimes resolve disputes, in the context of trademark opposition, it is insufficient. This approach lacks the legal force of a formal proceeding and does not prevent the registration of the potentially infringing mark. The competitor could ignore the concerns, proceed with registration, and the client would then be in a weaker position to challenge it. This bypasses the established legal channels for resolving such disputes. Finally, advising the client to simply monitor the competitor's activities without taking any immediate legal action is also professionally deficient. Monitoring is a component of due diligence, but it is not a substitute for asserting legal rights when a clear threat of infringement exists. Alabama's trademark laws provide a mechanism for pre-registration challenges, and failing to utilize this mechanism, when warranted, exposes the client to unnecessary risk and potential harm to their established brand. For professional reasoning, professionals should first identify the specific legal framework governing the situation, in this case, Alabama's trademark registration and opposition procedures. They must then assess the potential harm to their client's rights and determine the most effective and legally sound method to mitigate that harm. This involves understanding the procedural requirements and timelines for asserting those rights. When a competitor files for registration of a mark that is confusingly similar to a client's existing mark, the immediate and most effective legal recourse is to initiate a formal opposition proceeding. This proactive approach aligns with the principles of protecting intellectual property and preventing market confusion, as facilitated by state trademark laws. Question 15. Benchmark analysis indicates a new business in Alabama plans to launch a line of athletic apparel under the name Crimson Wave Gear. An established Alabama-based company, Crimson Tide Apparel, which sells similar athletic wear, has expressed concerns about potential trademark infringement. What is the most prudent course of action for the new business to take? Option A. Conduct a comprehensive trademark clearance search and consult with an Alabama intellectual property attorney to assess the likelihood of consumer confusion between Crimson Wave Gear and Crimson Tide Apparel based on the similarity of the marks, the relatedness of the goods, and the strength of the existing mark. Option B. Launch the Crimson Wave Gear line immediately, arguing that since the goods are both athletic apparel, they are too similar and therefore not infringing. Option C. Seek to register the Crimson Wave Gear trademark with the state of Alabama without conducting any prior legal analysis, believing that registration will automatically grant protection and negate any infringement claims. Option D. Proceed with the Crimson Wave Gear branding, assuming that the difference in the second word, wave versus tide, is sufficient to avoid any legal issues. The correct answer is A. Conduct a comprehensive trademark clearance search and consult with an Alabama intellectual property attorney to assess the likelihood of consumer confusion between Crimson Wave Gear and Crimson Tide Apparel based on the similarity of the marks, the relatedness of the goods, and the strength of the existing mark. Explanation. This scenario presents a professional challenge because it requires a nuanced understanding of trademark law in Alabama, specifically concerning the potential for infringement when a new product's branding closely resembles an established one. The core difficulty lies in balancing the rights of the established trademark holder with the ability of new businesses to enter the market and develop their own brand identity. Careful judgment is required to assess the likelihood of consumer confusion, which is the central test for trademark infringement under Alabama law. The best professional approach involves a thorough investigation into the similarity of the marks, the relatedness of the goods or services, and the strength of the existing mark. This includes analyzing the visual, phonetic, and conceptual similarities between the Crimson Tide Apparel mark and the Crimson Wave Gear mark. It also necessitates evaluating the marketing channels used and the sophistication of the relevant consumers. This comprehensive assessment, grounded in the principles of Alabama trademark law, aims to determine if there is a likelihood of confusion among consumers as to the source or sponsorship of the goods. This approach is correct because it directly addresses the legal standard for infringement by focusing on the likelihood of consumer confusion, a cornerstone of trademark protection in Alabama. An incorrect approach would be to dismiss the concern solely because the names are not identical. This fails to acknowledge that trademark infringement can occur even with dissimilar marks if the overall commercial impression is similar enough to cause confusion. Alabama law, like federal law, protects against marks that are confusingly similar, not just identical. Another incorrect approach would be to proceed with the Crimson Wave Gear branding without any legal review, assuming that as long as the goods are different e.g., one is apparel and the other is sporting equipment, there is no infringement. This overlooks the possibility that the goods or services could be considered related in the marketplace, or that consumers might believe the two brands are affiliated or endorsed by the same entity, even if the products are distinct. The relatedness of goods/services is a key factor in the likelihood of confusion analysis. Finally, an incorrect approach would be to rely on the fact that the crimson element is common in Alabama branding. While commonality can be a factor, it does not automatically negate the potential for infringement. The distinctiveness of the tide versus wave and the overall commercial impression of the marks must be considered in context. Professionals should employ a decision-making framework that prioritizes legal compliance and risk mitigation. This involves conducting thorough due diligence, seeking expert legal counsel when necessary, and carefully evaluating all relevant factors under the applicable jurisdiction's laws before launching a new brand. The primary consideration should always be whether the proposed branding is likely to cause confusion among consumers regarding the source or affiliation of the goods or services. Question 16. The evaluation methodology shows that a client in Alabama has developed a novel device for agricultural efficiency. Considering the historical development of intellectual property law in the United States, which has influenced Alabama's approach to patentability, what is the most prudent strategy for advising the client on securing patent protection for their invention? Option A. Conduct a comprehensive prior art search and analyze the invention against current federal patentability standards for novelty and non-obviousness, while acknowledging the historical evolution of these standards in U.S. patent law as interpreted by Alabama courts. Option B. Recommend that the client pursue protection under Alabama's state-specific intellectual property statutes, assuming these offer a distinct and more favorable pathway for patentability than federal law. Option C. Advise the client that the invention's potential commercial impact and the inventor's perceived ingenuity are the primary factors for patentability, given the historical emphasis on encouraging innovation. Option D. Focus the patent application strategy on demonstrating that the invention predates any similar concepts, emphasizing the historical first-to-invent doctrine as the paramount consideration. The correct answer is A. Conduct a comprehensive prior art search and analyze the invention against current federal patentability standards for novelty and non-obviousness, while acknowledging the historical evolution of these standards in U.S. patent law as interpreted by Alabama courts. Explanation. The evaluation methodology shows a scenario that is professionally challenging due to the inherent tension between promoting innovation and ensuring fair competition, particularly when considering the historical evolution of intellectual property law in Alabama. A practitioner must navigate the legacy of early patent doctrines, which were often more focused on encouraging invention through broad grants, against modern interpretations that emphasize novelty, non-obviousness, and utility to prevent stifling downstream innovation. The challenge lies in applying these evolving principles to a contemporary invention, requiring a deep understanding of how Alabama courts have historically interpreted federal patent law and its underlying policy goals. The correct approach involves a thorough examination of the invention's novelty and non-obviousness in light of the prior art, specifically considering how Alabama courts have historically interpreted and applied the standards set forth in federal patent statutes and landmark Supreme Court decisions. This approach acknowledges that, while the foundational principles of patent law are federal, their application and interpretation within Alabama are shaped by state-level judicial precedent and the specific economic and industrial context of the state. It prioritizes a rigorous legal analysis grounded in established patentability criteria, recognizing that the historical development of IP law in Alabama has been largely influenced by the adoption and interpretation of federal patent frameworks. This ensures that the patent application aligns with the current understanding of what constitutes patentable subject matter and meets the statutory requirements for patentability, thereby maximizing the likelihood of a valid and enforceable patent. An incorrect approach would be to rely solely on the perceived inventive spirit of the inventor or the potential commercial success of the invention without a robust prior art search and analysis. This fails to address the fundamental legal requirements for patentability, which have evolved over time to prevent the issuance of patents on obvious or already known subject matter. Such an approach ignores the historical shift in IP law towards a more stringent examination of novelty and non-obviousness, which was a direct response to concerns about patent thickets and anti-competitive effects. Another incorrect approach would be to focus exclusively on the historical first-to-invent principles that were once prevalent in U.S. patent law, without acknowledging the subsequent transition to a first inventor to file system. While understanding historical doctrines is important for context, applying outdated legal standards to a current invention would lead to an invalid patent. Alabama's IP law, like the rest of the U.S., operates under the current federal statutory framework, and historical analysis must inform, not dictate, the application of present-day law. A further incorrect approach would be to assume that Alabama has developed a unique, state-specific body of patent law that significantly deviates from federal standards. While state law can influence the enforcement and remedies related to patents, the core patentability requirements are established by federal law. Overlooking this fundamental federal preemption in patentability would result in a flawed legal strategy. Professionals should employ a decision-making process that begins with a comprehensive understanding of the current federal patent statutes and relevant case law. This should be followed by a thorough prior art search and analysis, applying the established criteria for novelty and non-obviousness. Historical context should be used to inform the understanding of how these criteria have been interpreted and applied over time, particularly within the judicial landscape of Alabama, but the ultimate determination must be based on present-day legal standards. This systematic approach ensures that legal advice and actions are grounded in current law and best practices, mitigating the risk of invalid patents and subsequent legal challenges. Question 17. Quality control measures reveal that Southern Charm Catering, a business operating exclusively within Alabama and providing event catering services, is seeking to protect its brand identity. The mark is used on menus, uniforms, and promotional materials associated with their catering operations. What is the most appropriate classification and legal consideration for Southern Charm Catering under Alabama intellectual property law? Option A. It is a service mark, as it identifies and distinguishes the catering services offered by the business. Option B. It is a certification mark, as it signifies the quality of the catering services provided. Option C. It is a collective mark, as it is used by a business operating within a specific region. Option D. It is a trademark for goods, as it is used in commerce to identify the business's offerings. The correct answer is A. It is a service mark, as it identifies and distinguishes the catering services offered by the business. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires distinguishing between different types of marks and understanding the legal implications of their use and registration under Alabama law. The core difficulty lies in correctly identifying the nature of the mark based on its intended use and the entity seeking protection, which directly impacts the scope of rights and enforcement. Misclassification can lead to improper registration, weakened legal standing, and potential infringement claims against the entity itself. Correct approach analysis. The best professional approach involves accurately classifying the mark based on its function and the entity using it. If a business offers services to the public and uses a mark to identify those services, it is a service mark. Alabama law, mirroring federal trademark principles, recognizes service marks as distinct from trademarks used for goods. Properly identifying it as a service mark allows for appropriate registration and protection under the relevant statutes governing marks used in commerce within Alabama. This ensures the mark receives the intended legal safeguards. Incorrect approaches analysis. One incorrect approach is to treat the mark solely as a trademark for goods, even though the entity provides services. This misclassification fails to recognize the specific protections afforded to service marks under Alabama law and related federal guidelines, potentially limiting the scope of protection and enforcement. Another incorrect approach is to assume that any mark used by an organization is automatically a collective mark, without verifying if the organization is a membership association or union, and if the mark is used to indicate membership or affiliation. Collective marks have specific requirements for registration and use, and misapplying this designation can lead to invalidity. A further incorrect approach is to consider it a certification mark, without confirming that the mark is used by someone other than the owner to certify the quality, origin, or other characteristics of goods or services provided by others. Certification marks have distinct legal standards and purposes, and their misapplication undermines the integrity of the certification process and the legal framework. Professional reasoning. Professionals should approach mark identification by first understanding the nature of the entity seeking protection and the purpose of the mark. Is it identifying goods, services, membership, or certification? This fundamental understanding dictates the correct classification. Consulting relevant Alabama statutes and federal trademark law, as it often informs state law, regarding the definitions and requirements for trademarks, service marks, collective marks, and certification marks is crucial. A systematic evaluation of the mark's use against these legal definitions will lead to the correct classification and appropriate protection strategy. Question 18. Strategic planning requires a thorough understanding of potential legal challenges. A client in Alabama is eager to launch a new line of artisanal cheeses under the brand name Southern Charm Cheddar. However, they have received a cease and desist letter from an established Alabama dairy producer who claims this name infringes on their long-standing trademark, Southern Charm Dairy, used for a variety of dairy products, including cheeses. The client believes their name is sufficiently distinct and that consumers will not be confused. As legal counsel, what is the most prudent course of action to advise your client regarding the likelihood of confusion under Alabama trademark law? Option A. Inform the client that since the marks are not identical, there is likely no significant risk of confusion and they can proceed with their chosen name. Option B. Conduct a comprehensive analysis of all factors relevant to the likelihood of confusion standard under Alabama law, including the similarity of the marks, the nature of the goods, marketing channels, and consumer perception, to provide a reasoned opinion on the infringement risk. Option C. Advise the client to proceed with the Southern Charm Cheddar name, as the client believes their branding is distinct and the junior user's mark is for a broader range of products. Option D. Recommend the client make minor cosmetic changes to the proposed name, such as adding a descriptor like artisan before Southern Charm Cheddar to differentiate it from the existing mark. The correct answer is B. Conduct a comprehensive analysis of all factors relevant to the likelihood of confusion standard under Alabama law, including the similarity of the marks, the nature of the goods, marketing channels, and consumer perception, to provide a reasoned opinion on the infringement risk. Explanation. This scenario presents a professional challenge because it requires balancing a client's desire for aggressive brand expansion with the legal imperative to avoid infringing on existing intellectual property rights, specifically trademarks. The core of the challenge lies in assessing the likelihood of confusion under Alabama trademark law, which is a fact-intensive inquiry with significant financial and reputational consequences for the client if misjudged. Careful judgment is required to navigate the nuances of consumer perception and market similarity. The best professional approach involves conducting a thorough and objective analysis of the likelihood of confusion. This entails meticulously examining all relevant factors under Alabama law, such as the similarity of the marks, the similarity of the goods or services, the strength of the senior mark, evidence of actual confusion, the marketing channels used, the degree of care likely to be exercised by consumers, and the intent of the junior user. This comprehensive review, ideally documented in a formal legal opinion, provides a reasoned basis for advising the client on the risks and potential strategies, such as seeking consent, modifying the proposed mark, or proceeding with caution. This approach prioritizes legal compliance and risk mitigation, aligning with the ethical duty to provide competent representation and sound legal advice. An incorrect approach would be to dismiss the concerns raised by the junior trademark owner without a detailed investigation. This failure to adequately assess the likelihood of confusion, particularly when presented with a cease and desist letter, risks overlooking genuine infringement and exposes the client to potential litigation, injunctions, and damages. It demonstrates a lack of diligence and a disregard for the client's legal obligations. Another professionally unacceptable approach is to advise the client to proceed with the new brand name solely based on the client's assertion that their mark is distinctly different without independent verification. This relies on the client's subjective opinion rather than an objective legal assessment, potentially leading to a flawed decision that ignores the legal standard for confusion. It abdicates the professional responsibility to provide an informed legal opinion. Finally, advising the client to adopt a name that is only superficially different from the existing mark, with the hope that minor alterations will avoid confusion, is also a flawed strategy. While some minor differences might be considered in a likelihood of confusion analysis, a deliberate attempt to create a confusingly similar mark, even with superficial changes, can be viewed as evidence of bad faith and increases the risk of a finding of infringement. Professionals should employ a structured decision-making process that begins with identifying the core legal issue, likelihood of confusion. This is followed by gathering all relevant facts, applying the specific legal tests and factors prescribed by Alabama law, considering the potential risks and benefits of each course of action, and ultimately providing clear, well-reasoned advice to the client, prioritizing legal compliance and ethical conduct. Question 19. In Alabama, a patent attorney is representing a client in a patent infringement lawsuit. During discovery, the attorney receives information suggesting that the patent in question may have been obtained through inequitable conduct before the U.S. Patent and Trademark Office, and that the client may be exaggerating the scope of their patent claims to gain leverage in settlement negotiations. Which approach would be most professionally responsible for the attorney to take? Option A. Conduct an independent and thorough investigation into the patent's validity and the client's conduct, discuss the findings and potential risks with the client, and advise on appropriate legal strategies, which may include settlement or withdrawal if the claims are found to be meritless or pursued in bad faith. Option B. Proceed with the litigation as planned, relying on the client's assertions of patent validity and the existing discovery, and focus on aggressively defending the client's position in court. Option C. Advise the client to strategically emphasize the perceived strength of their patent during settlement discussions, even if there are doubts about its enforceability, to maximize the settlement amount. Option D. Immediately file additional motions and aggressively pursue discovery to overwhelm the opposing party, without first thoroughly investigating the potential inequitable conduct or the client's exaggeration of claims. The correct answer is A. Conduct an independent and thorough investigation into the patent's validity and the client's conduct, discuss the findings and potential risks with the client, and advise on appropriate legal strategies, which may include settlement or withdrawal if the claims are found to be meritless or pursued in bad faith. Explanation. This scenario presents a professional challenge because it pits a lawyer's duty of zealous representation against the ethical obligation to avoid misleading the court and potentially engaging in inequitable conduct. The lawyer must navigate the complexities of patent litigation in Alabama, specifically concerning the enforcement of a patent that may have been improperly obtained or is being asserted in bad faith. Careful judgment is required to balance the client's interests with the integrity of the judicial process and the principles of patent law as governed by Alabama courts and federal patent statutes. The best approach involves a thorough, independent investigation into the patent's validity and the client's conduct, followed by a candid discussion with the client about the potential ramifications of pursuing a weak or fraudulent claim. This approach prioritizes ethical obligations and adherence to Alabama's rules of professional conduct, which require lawyers to be truthful to the court and to avoid prosecuting frivolous claims. If the investigation reveals significant issues, the lawyer must advise the client on the risks and explore alternative resolutions, which may include seeking to withdraw from representation if the client insists on pursuing an unethical course of action. This aligns with the lawyer's duty to uphold the law and maintain the integrity of the legal system. Pursuing the litigation without further investigation, based solely on the client's assertion of validity, is professionally unacceptable. This approach risks violating the duty of candor to the tribunal and could lead to sanctions for filing a frivolous lawsuit under Alabama law and federal patent rules. It also fails to adequately investigate the factual and legal basis for the claim, which is a fundamental aspect of competent representation. Advising the client to bluff or exaggerate the strength of their patent during settlement negotiations, even if not directly presented to the court, is also professionally unacceptable. This borders on misrepresentation and could be construed as inequitable conduct, which can impact patent enforceability. It undermines the principle of good faith negotiation and could lead to ethical disciplinary action. Immediately filing suit without any internal review or discussion with the client about the potential weaknesses of the patent is also problematic. While prompt action is often necessary in patent litigation, a complete lack of due diligence before initiating a lawsuit, especially when there are red flags, can be seen as reckless and potentially harmful to the client. If the case is quickly dismissed or sanctioned, professionals should employ a decision-making framework that begins with a thorough understanding of the facts and the relevant legal and ethical obligations. This involves active listening to the client, conducting independent research and investigation, and critically evaluating the strength of the case. When ethical concerns arise, professionals must prioritize their duties to the court and the integrity of the legal system, even if it means advising the client against their initial desires or, in extreme cases, withdrawing from representation. Open and honest communication with the client about risks and ethical boundaries is paramount. Question 20. Investigation of a novel chemical compound developed by an inventor in Alabama reveals that a similar compound, disclosed in a 2018 scientific journal article, exhibits a certain level of therapeutic efficacy. The inventor's compound, when tested, shows a statistically significant increase in efficacy, measured by a text efficacy index /. The prior art compound's efficacy index is /. Prior equals 75 /. The inventor's compound achieves an efficacy index of inventor equals 90 /. If the inventor's attorney were to argue non-obviousness based on this improved efficacy, what is the percentage improvement in the efficacy index, and what is the primary ethical consideration regarding the disclosure of the prior art journal article? Option A. The percentage improvement is approximately 15%, and the primary ethical consideration is to focus solely on the novelty of the inventor's compound and not the comparative efficacy. Option B. The percentage improvement is approximately 20%, and the primary ethical consideration is to argue that the prior art is not sufficiently similar to warrant disclosure. Option C. The percentage improvement is approximately 20%, and the primary ethical consideration is the duty of candor and good faith to disclose all known material prior art, including the 2018 journal article, to the USPTO. Option D. The percentage improvement is approximately 15%, and the primary ethical consideration is to only disclose prior art that directly anticipates the invention to the USPTO. The correct answer is C. The percentage improvement is approximately 20%, and the primary ethical consideration is the duty of candor and good faith to disclose all known material prior art, including the 2018 journal article, to the USPTO. Explanation. This scenario presents a professional challenge for an inventor and their patent attorney in Alabama due to the critical need to accurately assess patentability criteria, specifically novelty and non-obviousness, while also considering the potential for financial gain and the ethical obligation to disclose relevant information. The core difficulty lies in balancing the desire to secure patent protection with the legal requirement of full and truthful disclosure to the United States Patent and Trademark Office (USPTO) under Alabama patent law, which is governed by federal statutes. Misrepresenting or omitting information can lead to inequitable conduct, rendering the patent unenforceable. The best professional approach involves a thorough and transparent assessment of prior art, even if it appears to diminish the invention's novelty or non-obviousness. This includes a detailed quantitative analysis of the prior art's technical features and their contribution to the claimed invention. Specifically, when evaluating novelty under 35 U.S.C. Section 102, the inventor and attorney must determine if any single prior art reference discloses all the elements of at least one claim. For non-obviousness under 35 U.S.C. Section 103, the analysis extends to whether the differences between the claimed invention and the prior art are such that the invention as a whole would have been obvious at the time the invention was made to a person having ordinary skill in the art. This requires a qualitative assessment of the prior art's teachings, motivations, and potential for combination. The quantitative aspect arises when assessing the degree of difference or improvement. For instance, if a prior art device has a certain efficiency rating, and the new invention offers a quantifiable improvement, the percentage increase can be a factor in demonstrating non-obviousness. A calculation demonstrating a significant, unexpected improvement in performance, such as a \delta text efficiency equals text new efficiency text prior art efficiency or \delta text efficiency 0 and is statistically significant, would support a non-obviousness argument. The attorney's duty of candor and good faith requires disclosing all known information material to patentability, including potentially detrimental prior art, and presenting arguments for patentability based on objective evidence. An incorrect approach would be to selectively present only the most favorable prior art, and to downplay or omit references that weaken the patentability arguments. This constitutes a failure to meet the duty of candor and good faith, potentially leading to a finding of inequitable conduct under 35 U.S.C. Section 282b, 1 and 37 C.F.R. Section 156. Such an approach risks rendering any granted patent unenforceable. Another incorrect approach is to rely solely on a qualitative assessment without any quantitative data to support claims of significant improvement. While qualitative arguments are important, objective, quantifiable data demonstrating a superior result compared to the prior art is often crucial for overcoming obviousness rejections, especially when the prior art suggests similar approaches. For example, if the prior art achieves a certain output of y units per hour and the invention achieves y plus delta y units per hour, failing to quantify delta y and demonstrate its significance can weaken the non-obviousness argument. A further incorrect approach is to assume that any improvement, regardless of its magnitude, automatically confers non-obviousness. The USPTO requires that the improvement be significant and not merely a predictable result of applying known techniques. For instance, a minor increase in speed, say from 100 RPM to 105 RPM, might be considered obvious if the prior art discusses methods for increasing rotational speed. Quantitative analysis showing a frac 105 100 times 100 percent equals 5 percent increase might not be sufficient to demonstrate non-obviousness if the prior art suggests such incremental gains are routine. The professional decision-making process for such situations requires a systematic approach. 1. Conduct a comprehensive prior art search. 2. Analyze each prior art reference against the claimed invention for novelty and obviousness. 3. Quantify any asserted improvements in performance or efficiency using objective data. For example, if the invention claims a reduction in energy consumption, calculate the percentage reduction. Text percentage reduction equals frac text prior art consumption text new consumption text prior art consumption times 100 percent 4. Prepare a detailed report outlining the findings, including both supporting and potentially refuting prior art. 5. Disclose all material prior art to the USPTO. 6. Develop strong arguments for patentability, supported by both qualitative reasoning and quantitative data where applicable. 7. Maintain open and honest communication with the client regarding the strengths and weaknesses of the patent application.